record, Joseph Carey representing Mr. Doms, present before the court.
Elissa Levan for Mr. Deutsch.
Status?
We obtained a temporary peace order a week ago, and we're here for the final.
Can the case be worked out?
No.
How do the parties know each other?
Mr. Deutsch is the city manager of the city of Bowie. Mr. Doms is a disgruntled citizen.
Disgruntled citizen? Okay, what are the allegations?
The allegations are that Mr. Doms has engaged in a campaign of character assassination and harassment, which are directly relevant to the peace order, except that the conduct has escalated over time. Email communication on April 16th threatening grievous bodily harm to the petitioner. And although it was couched with disclaimatory language, Mr. Doms' history is such that Mr. Deutsch has no confidence in the disclaimer that Mr. Doms is merely fantasizing. And I think the fact that he fantasizes in writing to such a large audience is indicative of the fact that he has some internal intention or likelihood of carrying through on those
What's
threats.
the genesis of the dispute in your mind's eye?
Mr. Doms is of the view that Mr. Deutsch has served too long as the city manager. He has also accused him of...
Is Mr. Doms on the city council?
No, sir.
Well, then he doesn't get to make that call.
No, sir.
Is he Mayor Robinson? Is Mayor Robinson still the mayor?
Yes, sir.
He's been a mayor a long time.
Several terms.
Okay.
Mr. Doms has also accused Mr. Deutsch of being a Nazi, a fascist, of being corrupt, of being garbage, of being all kinds of sort of over-the-top, delusional type accusations, of having engaged in collusion to manipulate the election, all sorts of those things.
How does he... Never mind. Okay. Mr. Carey,
May I?
tell me why the case can't be worked out in some way.
Well, let me ask you this. Are we talking about the activities in the last 30 days? I think under the statute, I think that's the issue, is what
Okay.
activities have taken place in the last 30 days.
That he's right about that. I mean, that's a predicate that we have to... Is there something within 30 days?
Yes, sir. The most recent email, the one that I spoke about with the threat of grievous bodily harm, was on April 16th. The reason I have brought up the prior incidents is not that the petitioner is entitled to a peace order with respect to those incidents, but they go to whether or not he is in reasonable fear of imminent bodily harm.
I get it. Does that answer your question, Mr. Carey?
I understand counsel's position. I would note that essentially, as I understand it, this is a harassment issue. And the petition is allowed to set forth 9 separate events which could trigger the statute. The only event that I see that applies is a harassment statute. And there's not an issue of false imprisonment or assault or rape or trespass, stalking, as I understand it. And you know, we don't get any discovery in these cases, but in looking through this, we have an email that's dated April the 16th, which is a political email dealing with my client's exercise of his rights under the First Amendment to express his displeasure with the city government.
Let me stop you right there. Would you mind right now, just as we're chatting, can I look at the email?
Absolutely.
Your Honor, they are attached to the petition, I believe, but if not, I can give you...
It's a thick file. Just
Yes,
hand it.
Exhibit A is the...
Everybody have a seat,
Certainly.
please. And there's no doubt that your client was the author of this document, right?
Yes, sir. Yeah, that's correct, Your Honor.
Okay. With copies to... Who's Geraldine Valentino Smith?
Councilwoman, Your Honor.
Councilwoman.
In Bowie, the individuals who are shown as having received the emails are all of the city council people, all of the county council people, the state's attorney, the General Assembly members, I believe. In most of these emails, it includes the General Assembly people as well and various other individuals. In addition, Mr. Doms asserts that he has a substantial list of blind copied individuals whose identities we do not know.
And since we're dealing with Mr. Doms' email, as I understand it, it's a reply email to an email that was sent by the councilwoman requesting suggestions concerning the city government.
Okay, got it. All right, and Mr. Carey, I assume it's this paragraph which begins in boldface type. This next paragraph is theater of the mind and not to be taken literally.
That I would assume.
And then in the body of that, and then at the end it says end of theater of the mind. And then within the text of that paragraph, this is also in boldface type. And my next words are not capitalized to be taken literally. And then it goes into some...
As I'm a very nonviolent person.
Yes. Well, that's not highlighted,
right.
but it's there.
Right.
But that's what we're focusing on.
Yes, Your Honor, yes.
Okay.
Judge, if I may approach, just briefly, I have, and I'm sure the court has this, this is a copy of the harassment statute that is referred to in the peace order statute. It's against the law to harass someone in violation of 3-803.
Your Honor, we're not proceeding under the harassment statute. Mr. Carey omitted the first part of the peace order statute, which was to place someone in fear of bodily injury, and that is
Imminent,
the section.
serious. I assume that
Imminent
since the
bodily
imminent has been
injury.
defined as immediate, that an email which was sent would not necessarily qualify for imminent. And the reason I say that, Judge, is that entire issue was dealt with by the Supreme Court in 1969 in the case of Brandenburg versus Ohio. And in that case, the appellant was a member of the Ku Klux Klan who was advocating violence, the overthrow of the government using terrorism. And what the Supreme Court said was the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action.